That's going to give a few folks some time to get a wonderful seat in our intimate little venue that we have here. I think that's everybody that's going to be coming in from the cafe that we have here. Well, welcome to the MARN Art and Culture Hub, Milwaukee's newest venue that is directly engaging and dedicated to artists. And our little saying here is that we built this place, artists built this place. So it's built by artists for artists and those who appreciate their work. So again, welcome to our wonderful facility here. Hope to see you back many, many more times. It's an absolute honor and we're very proud to be co-sponsoring tonight's event. I'm going to try to get this microphone set up so that when the guests actually get up, they'll be absolutely dialed in. That's kind of what I'm doing, by the way. All of our engineers, our team are over there making sure that all the levels are good and all the lighting and everything that we're going to need to make tonight a wonderful event. So thank you to my team. So we're excited to have Dan Kattman and, of course, Tom Lemke here. We're just thrilled, and we're very thrilled that Pam has thought of us to help co-sponsor this wonderful event. So before we get going, let me actually introduce myself. My name is Mal Montoya. I'm the president and CEO of the Milwaukee Artists Resource Network, and it's my honor to make our space available for groups such as this wonderful group. And before I go any further, yes, I get to come up here and do the sound check, but I've got a tremendous team that works very, very, very hard to make this all possible, starting with Ashley, Nicole, Riley, Christina, Sam, Whitney. I don't know if I've left anybody out. I think that's all of us. But thank you all to the team here that's been working very hard. Also, Tom and your wife, working very hard. Thank you so much for all of your contributions as well. Something that's very important for us as an organization, we've tried to create a very simple statement that kind of shares our sentiment as an organization being here in the historic Third Ward, and that's a land acknowledgement. So if you just give me a quick moment, I'm going to read what we have put together. The hub is located in the historic Third Ward of Milwaukee, the traditional Potawatomi, Ho-Chunk, Menominee homeland, where people of Wisconsin's sovereign Anishinaabe, Ho-Chunk, Menominee, Oneida, and Mohican nations remain present. So thank you for letting me read that to you. I'd also like to let you know about one of our partners. I don't know if you know of Interval. Interval is a great provider of coffee on the east side. We're very fortunate to have them as our partners in the cafe. So please visit them on the way out. I'd also like to let you know that our marketplace is full of art from local artists. Their contributions, of course, are very important to us as well. And one last quick thing, we are a membership organization. It's $60 a year. Every single dollar that you give helps provide for programs such as this, as well as support for those local artists. So if you're a believer in the arts, feel free to ask Whitney or any of the team here for information regarding that. We're open to the public, but again, that membership helps drive a lot of what we do here. Oh, I think I've done enough sound checking here, so without any further ado, I'm going to go ahead and turn this microphone over to my very good friend, Pam Brodbar. Thank you, Pam.
We, first of all, would like to extend our thanks to MARN for partnering with us on the last meeting and tonight. Mal, Nicole, Ashley, Christina, Whitney and Riley and Sam have made CoPA feel like family, and we really appreciate that. This is a beautiful facility, a perfect atmosphere to talk about art. We're delighted to be here. I encourage everyone from CoPA, if you're not already a MARN member, to become a MARN member. They have wonderful member shows. They have a lot of stuff going on. And likewise, if you're MARN members and not CoPA members, come CoPA for $65 a year. And again, those, it's really affordable, I think, for the kind of programming that we offer and the things that we do. So we'd appreciate that. Our goal is to present programming that enriches the artist experience, regardless of medium. We figure we have a lot to learn from each other and everything to gain by joining forces in the greater arts community. If anyone has a suggestion about a speaker or a meeting topic, oh, there we are, please email us at info@copamilwaukee.com. That goes directly to Aaron and myself. Your emails will be given our immediate consideration and a very timely response. Little bit of housekeeping. We're working on a CoPA member exhibition, the annual member show, for hopefully this spring. We've been delaying the project in the hopes that we'll be able to host a live exhibition rather than a virtual one. But as you can imagine, there have been hiccups in terms of venues, you know, the after times here. But we're on it, and we hope to make an announcement very soon. On Thursday, November 18th at 5:30 p.m., CoPA and MARN members are invited to a private tour and talk by photographer Jan Sayre at the Warehouse at 1635 West St. Paul. All the details will be on our website in the next couple of days. On first look, the 64 photographic works in China Then and Now, Jan Sayre, are about China. They depict the old town Hutong neighborhood streets, the restful scholar's garden, and the ultra-contemporary world of maglev bullet trains that travel 375 miles an hour. On second look, the exhibition is about the passing of time. Situating prints of her meticulously curated compositions within this immersive time-traveling exhibition, Jan Sayre asks what is remembered and what is forgotten, beckoning visitors to experience China through her. In addition to Sayre's photographs, the exhibition includes a painting of the Tiananmen Square massacre, as well as the original video illustrated by her. Other works include 2 large figurative ceramics by Pamela Luang, never before exhibited in the United States, hand-colored brass rubbings, and other Chinese objects. Please join us for this very special event. Again, that is Thursday, November 18th, 5:30 p.m. at the Warehouse. I am now going to introduce Daniel Kattman. Dan is a shareholder and partner at the law firm of Reinhardt, Warner Van Duren, where he has developed a unique legal practice that reflects the convergence of brand, media, and technology in the digital age. He's passionate about helping clients develop, protect, and grow their trademark portfolios and overall brand. He works with companies of all sizes, including startups, as well as companies with sizable trademark portfolios on domestic and international legal issues related to the following areas of law, but by no means limited to them: internet, e-commerce, domain name disputes, online privacy and social media, and copyright law and copyright enforcement matters. Tonight, we were going to have we're reversing the order of things. So Dan is going to open with his photographing and recording public officials and law enforcement. This seems like an extremely timely topic for us. I honestly don't know what my rights are as an individual if I see something happening involving the police, if I can photograph them or record them with my phone. I've seen people do this and seen them have their phones thrown to the ground and smashed and told they're not allowed to do that. I'm guessing that's probably not the case, but knowledge is power. So that's how Dan is going to begin the evening. And he will save a spot toward the end of his program for some brief pointers on copyright law. Every single artist, whether you're spoken word, music, painting, photography, whatever it happens to be, you end up with your work on the internet, whether wittingly or unwittingly. And how do you protect your work? Are there, what are we supposed to do? Do you register it? Do you copyright it? So, the floor will be open to questions, specific questions about copyright if you have any. So, without further ado, our good friend, Dan Kattman.
Sam. So I guess the question, am I better off with the microphone or without the microphone? All right. Oh, gotcha. Okay. All right. Well, so as Pam mentioned, this is a pretty fascinating topic because most of us don't really know what our rights are. And this is an area where intellectual property, copyright law overlaps with constitutional law and criminal law. And it's not very often that those areas of law converge. But this is very timely. Right now we have a trial going on in Kenosha with Rear House, which is a self-defense case involving a shooting at protests. However, what's fascinating about that case is the amount of video footage that's being used by both the prosecution and the defense. And that footage includes drones used by the FBI. It includes video created by or taken by police. Countless videos of bystanders, protesters, news media, all converging at a single location. So this is something that is happening to us daily all across the country. And I think it's important for you to understand your rights are as a photographer. So these are sort of the topics, and Pam, I'll give you my presentation. If people want a copy of it, you're free to pass it along to people. So these are really the main topics. The first question is, do you have a right to photograph law enforcement? And when I say law enforcement, I also refer to political officials. This could be politicians, it could be the mayor, city officials. Do you have that right as a bystander? Do you have that right as a suspect? You are a suspect. Can law enforcement confiscate your phone or your camera or whatever device you've got? Can they destroy your phone, damage it, or put the media out and destroy the media? What can the police lawfully do in response to you reporting that? And then what should you do? What is the steps that you can take to protect yourself so that you are abiding by the law? And then lastly, can you secretly record? So most of the conversation is about what you can do in public, but what can you do secretly without necessarily the knowledge of the subject? So let's just start right off the bat. We have a very strong First Amendment right. This is the overarching right that we all have, which is the right to peacefully assemble and protest. And that includes the right to photograph and videotape the police or any public officials in a public space. So that is the key. If the police are in a public space, or you are in a public space and can see something going on from that public space, you have the First Amendment right to photograph it, record it with any device that you might have, except for drones. We won't talk about drones, but that's a whole other topic. But generally, a camera, a phone, any sort of basic handheld recording. We also have the Fourth Amendment, which prevents us from unreasonable or unlawful searches and seizures. And if a law enforcement officer takes your phone, they grab the phone from your hand, they have now seized your property. If they look at the contents of that, you have an unlawful search unless they have a warrant. And if you have a camera that has a chip in it or film while you roll, them taking that film out or that media card out of the camera is also a seizure. So one caveat on everything I'm going to talk about tonight, this only applies to the United States. Outside of the United States, nothing that I'm talking about applies. You should assume that outside of the United States, the police can do whatever they want with your phone and whatever they want with the media, and probably arrest you with photos or videos of public officials outside of the United States. Okay, so the fundamental question, can I record law enforcement as a device? The general answer is yes. Under the First Amendment, you have the right to photograph, videotape, or record the audio of law enforcement or public official if that person is acting in their official capacity. So if you're a peeking Tom and you're peeking through the window of a police officer's house and they're not on duty, that would be a violation. But if the police officer is acting as a police officer, has duties, you have the right to videotape. The officers in public, the officer is on your property, okay, so you are out in your house or on your property, or both you and the officer are on property that you are granted permission to be on. And this is an issue about trespassing that overlaps with these rights. So if I invite a friend over to my house and police knock on my door and break down my door to arrest me, my friend who I've invited to my house has the right to be there. They are not trespassing on my property. So they have the right to videotape whatever happens on my property. If, on the other hand, a person breaks into a building or something without permission, they still have the right to videotape or record the police, but they may be committing trespassing. And the person who owns that property would have the right to press charges. Police will sometimes, though, use that as a way of controlling the situation and say, well, you're trespassing, and therefore you can't report us. Well, sometimes the police don't necessarily ask the person who owns the property whether he's trespassing or not. But that is sometimes the impetus behind the situation. Yeah. Well, a shopping mall is generally public. Okay, so unless the shopping mall enacts some sort of policy that prevents you from, like, after hours, you break into the shopping mall, that'd be trespassing. But if it's during regular business hours, really the question is, does the police officer have an expectation of privacy, or does anyone have an expectation of privacy? And generally speaking, in a shopping center or a retail establishment, you don't have a right. Yeah, those would be generally considered public spaces. You would not have a expectation of privacy at a bar, unless maybe you were in the bathroom at the bar. That would be a different circumstance. If you're at the bar and you're allowed to be there, then that would be considered public space. No one has a right of an expectation of privacy when they're at the bar. So that's sort of general. Retail spaces. Pretty much any space where the public is allowed, without any sort of restriction. Like Pam and I were talking earlier about, well, what about concerts? Okay, well, the owner of the concert venue may prohibit you from bringing a camera into the concert venue, and that is them exercising their control over their own personal property, controlling the use of video recording devices. The question is whether you would have an expectation of privacy in that location. If the doors are open or there's big glass that anyone can see from the street, someone in that lobby would not have an expectation of privacy. When you are trespassing, you cannot get pictures. So it all comes down to who controls the property. Sure. Actually, here, okay. All right, maybe that's better. Okay, so these are basically the guidelines you should follow when you are on someone else's property. Are you there with permission or without permission? Realize that the limitation imposed on that property is imposed by the owner of the property, not law enforcement. Law enforcement can't say, hey, you're trespassing, unless they've actually been told by the property owner that you are trespassing. The owner of the property has the right of privacy, potentially, if it's like a private space, so they can tell you to stop recording if you're on their property. Realize, though, as I mentioned, law enforcement can arrest you for trespassing if the property owner says that you're not supposed to be there, or that you are not supposed to be videotaping or recording at that place. Okay, so the next question then is, the general rule as a bystander is you can videotape law enforcement. What if you're the suspect? The short answer is that the First Amendment still applies until you are actually arrested or detained by the police. So generally, you have a right to videotape or record law enforcement, even if you're the subject matter of their investigation, up until the moment that you are either arrested or lawfully detained. And arresting, being arrested is very cut and dry. They will say, you are under arrest, okay? Being detained is a little bit more ambiguous, and that's another topic that I'll touch on here. So, here, I think it's out of order, but I may jog back and forth a little bit. But as it also relates to recording, can law enforcement confiscate your media device or your camera? The Fourth Amendment says no. It's an unlawful search or seizure unless they have a warrant. Okay, so they have gone to a judge or magistrate and obtained a warrant to obtain your phone or your media device or media chip, or you give them permission. You're on the street, you videotape something that happened, the police say, hey, can I see what you videotaped? And you say, yeah, sure, here it is. You've now just given permission to the police officer. They now can look at your phone. It's no longer unlawful search and seizure if you give them permission. Okay, so can they destroy your media? Same thing applies. The answer is no. The Fourth Amendment prevents them from seizing your property, and if they destroy your property, they definitely have seized it and have violated the Fourth Amendment. Same thing applies if they delete the media. If the police, we've heard stories of police taking people's cameras, taking their media devices, and the repercussions for the police are actually pretty substantial. Those police now can be subject to liability for tampering with evidence. Your phone may have evidence of what actually happened in the crime. The police may be guilty of obstructing justice, or they themselves may be hiding criminal activity that they were engaged in, planting evidence, or they're corrupt in some manner. So the short answer is police cannot destroy the media under the Fourth Amendment, and because they themselves, in doing so, may violate these other laws, like obstruction of justice, tampering with evidence, etc. So what can law enforcement do? So first of all, the general rule in about every state is that if a police officer orders or commands you to do something, you need to comply with that. There are lots of exceptions to that. But if a police officer says, stand back, or go over there, you have to comply with that. If the police officer says, stop videotaping me, that you can say, no, I have a right under the First Amendment to videotape. So there are certain orders that you have to abide by, and certain orders that you do not have to abide by. Hand me your phone. You do not have to hand the police officer your phone if they ask you to. Get away from the crime scene. You need to comply with that, because that is impeding their investigation for that. So basically, they can order you to comply with anything that allows them to do their job, basically. Probably the easiest way to understand it. But they can't cross the line and infringe upon your First Amendment rights when they order you to do something. They also, so that's sort of the general rule. If you disobey law enforcement commands, realize that you run the risk of being subject to being arrested for obstruction of justice, disorderly conduct, or in some states, obstructing a peace officer. So that's an ambiguous term. Different states have different terminology for that term. So the problem that we have is we have the First Amendment, which is very, very strong. Courts are very clear that you have a First Amendment right to videotape the police. But the police will use the situation to their advantage sometimes to argue that you were obstructing justice or that you were engaged in disorderly conduct. And this is where there's a lot of litigation around this. There are a lot of attorneys that are defending a documentary filmmaker, for example, who's been charged with disorderly conduct. And that was the impetus that the law enforcement used to stop them from videotaping a situation. And whether that person was actually obstructing justice or engaged in disorderly conduct is something for a jury to decide. It's not not black and white. It's not clear cut. If you are, if you've got a camera and you are in the face of the police officer, in their way, or you're preventing a police vehicle from getting to a scene, or you are potentially destroying evidence at a crime scene, those are all pretty clear-cut examples of you obstructing justice, engaged in disorderly conduct. But if you are, 50 feet away, just videotaping from the side, that's unlikely to be disorderly conduct. So the line of when you cross from lawful to unlawful activity or behavior depends on the circumstances. It depends on your conduct. It depends on your actions. So you need to be very mindful of what you are doing when you are videotaping law enforcement. Of course, there are plenty of cases where law enforcement has been known to abuse, your right to record, using these three areas of the law as sort of the justification for it. In response to that, in response to police sort of blurring the lines of what you can and cannot do, some states have actually taken a very proactive step to indicate what your rights are. Colorado is a great example. They passed a law that gives citizens, private citizens, a cause of action against a municipality or a state if law enforcement violates one of these laws. So if law enforcement breaks, deletes, or seizes your camera, they intentionally interfere with your attempt to record an incident, they retaliate against you, they concoct a crime against you in an attempt to, in retaliation for you videotaping them, or they refuse to return your camera after you've given it to them or they've confiscated it. Those actions in Colorado give you a cause of action to sue the state or the municipality, and you get your attorney fees plus damages. So there's actually an incentive for you to file a complaint and pursue these kind of actions. Not every state has done this. Colorado is sort of unique in this situation. So how do you conduct yourself? How do you behave in a situation where law enforcement is engaged in whatever they're investigating a crime, arresting somebody? Well, it's kind of common sense. A lot of these things are common sense. The first one is be polite. Okay. And being polite is sort of ambiguous. That includes standing back, not shouting at the police officer. Don't taunt people. Think of what is the best way for you to be at that situation. Don't resist. If the police officer says, "Hey, go over there," you can still videotape from over there. And if you resist and you get in their way, well, now it's disorderly conduct, perhaps. So you shouldn't resist reasonable requests by law enforcement to relocate yourself, as long as they say, "Hey, don't." If they say don't videotape, that's different than them saying, "Go, videotape it from over there." Hold your camera close to yourself. Don't hold it out like this. Okay. I mean, this sounds like common sense, but there are cases where police have mistaken people's, dark black iPhone case as a firearm. If a police officer confronts you and says you cannot record, turn your camera off, or give me your camera, there's some basic things that you can ask in those circumstances to get a feeling for the situation. First one is, am I free to go? The police officer tells you to stop, hand me your camera. A natural or the best sort of response to that is, am I free to go? Am I being detained? And I'll get into what happens depending on what the police officer says. If it's a little more serious than that, they've grabbed hold of you, they've grabbed your phone. Am I under arrest? Okay, those two questions are very important to understand at that particular moment. Am I free to go, or am I being detained, or am I under arrest? If law enforcement says you are not free to go, you are now being detained at that moment. Maybe unlawfully, but maybe also lawfully. If they have not said you are under arrest, they've simply said you're being detained or you're not free to go, it's okay for you to say, well, what crime am I being suspected of committing? You also can say, officer, I have a First Amendment right to videotape. Okay, there's nothing wrong with you, reminding the police officer that you have this right. Now, how the officer is going to react in that is another question, but those are the things that you should ask. What am I being, what crime am I suspected of committing? And, hey, I have a First Amendment right to videotape you. If law enforcement says you are under arrest, stop, okay? Put your phone down and don't say another word other than, I want a lawyer, okay? And people joke about this all the time, but I have to stress that this is very important. We've all heard it on crime shows. They can use whatever you say against you in a court of law, blah, blah, blah. Your Miranda rights. That is true. That is their job, to use whatever you say as evidence. So if they say you are under arrest, stop doing what you're doing and sort it out later. Don't say anything. Say, I want to speak to a lawyer, and that's it. Don't say anything more. Don't do anything more. Don't resist arrest, of course. Don't continue to try to videotape or record the situation. Just sort of relax and let the system play out and let the lawyers do what they do. These are kind of important things to realize in these types of situations, because typically when you are recording police engaged in enforcing some action, it's high stress. Police officers under stress. People around the police officer are under stress. And as a bystander videotaping the situation, you don't want to add to that stress or be the target of that stress. So these are important guidelines to understand that notwithstanding your First Amendment rights, notwithstanding your Fourth Amendment rights, when you are under arrest, the ball game changes. It's now an issue of whether you actually committed a crime or not. And you don't debate that or decide that at the time that you're getting arrested. Okay? You decide that later. So, all right, what about Wisconsin? So, Wisconsin actually has a code of conduct that police officers arguably have been trained for. There's some debate as to whether this is being trained universally among Wisconsin law enforcement. But it's basically a policy. It's guidelines on what law enforcement should do when they encounter somebody who's videotaping them. And the policy and your right to record law enforcement in Wisconsin was affirmed in 2012 in a case ACLU versus Alvarez. And so everything I'm talking about, your right to videotape police officers and law enforcement in Wisconsin, it is constitutional at the federal level and under the Wisconsin Constitution, and it is sort of good law. So because of the Alvarez case, we have this code of conduct. And it sort of aligns with everything I've been talking about so far. It applies to public spaces or locations where a person has a right to be present. So that could be a retail establishment, a bar, a street. It's not necessarily a place where someone has a reasonable expectation of privacy. As a photographer, you must maintain a reasonable distance from the police. Okay, you can't interfere with their activities. So the only way to not interfere is to stand back. And the great thing is our cameras have zoom. You can zoom in. They have amazing capabilities. You don't need to get up, close to a police officer to capture the situation. You can't obstruct their activities. And obstruction, it takes on different situations. It could be your vehicle blocking their vehicles. It could be your person blocking their vehicles or them. It could be you stumbling into a crime scene where there's evidence that still needs to be processed. There's lots of ways that you can obstruct. Simple solution is stand back and don't walk into the crime scene. Don't insert yourself into the situation. Recording must be conducted in a manner that doesn't unreasonably impede the movement of emergency personnel, vehicles, and equipment. That's what I just said. And you can't jeopardize the safety of pretty much anyone, yourself, the police, other witnesses, other third parties, just to get that shot, to get the right angle. If you're putting some people in harm's way, the police now can arrest you for disorderly conduct or obstruction, etc. So these are the guidelines that Wisconsin law enforcement has been told. So now I'm going to move on to, just to complicate everything. So far, everything should be pretty straightforward. You're in a public setting. In Wisconsin is what we call a one-party consent state. That means that if you're on the phone or you're in a room and you're recording somebody, only one person needs to consent to that recording, which is you. Okay, you're the one person. You might own the phone that's doing the recording, but in Wisconsin, one person, namely the person who's doing the recording, has to consent to the recording. There are 11 states that are what we call two-party consent states. Those are listed on the slide. And in those states, even though whether there's 2 people or 20 people, the law is that everyone that's being recorded has to consent to being recorded in those states. Okay? So when you are recording in Wisconsin, you don't need permission from anyone else that you're recording in Wisconsin. If you're in one of these states that's a two-party, you do need to consent. Well, how do you do that? You could arguably stand up and say, all right, I'm recording. If you don't want me to record, leave. They also could say, well, no, just turn off your phone. You're not allowed to record. Okay, and you'd have to comply with that. That's where it gets complicated. Okay, this is dealing with private citizens primarily. Okay, it only applies though when people have a reasonable expectation of privacy. So I don't know if any of you saw one of my earlier presentations at CoPA on ethics of street photography. But the general rule is that when you are out in public, you have no expectation of privacy. I can literally walk up to you and take your picture, and there's nothing you can do to stop me from doing that. So if people have a reasonable expectation of privacy, these consent laws apply. So you're in a room, you've got your camera in your shirt pocket, and it's secretly recording. Or you're on the phone, and you're secretly recording the phone conversation. Those require some degree of consent. You also have to be part of the conversation. If I put my phone and leave the room and it's recording, I could be guilty of wiretapping or illegal eavesdropping. Okay? So it's really if I'm actually on the phone with you and I'm recording the conversation, that I can do. But if I've wiretapped your phone or hacked your computer or left my phone recording underneath the table, that would be illegal if the people in the room have a reasonable expectation of privacy. So in some states, law enforcement has tried to use these consent laws to say, well, this is a two-party state. The police didn't consent to you recording. In that situation, the First Amendment really trumps the public official or law enforcement's right to impose this consent law. So really the consent law only applies to private individuals who have a reasonable expectation of privacy. So if law enforcement ever says, hey, this is a two-party consent state, or in Wisconsin they say, I didn't consent to this. The short answer is 1, Wisconsin is a one consent state, and 2, my First Amendment right trumps the consent laws. So they don't matter. And this was all upheld in a relatively recent case, 2020, where First Circuit, which I think is Massachusetts, they invalidated a law passed by Massachusetts that was, the law basically said that it was illegal to do what they call surreptitious recordings of law enforcement or public officials. And it was really a law enacted to prevent people from secretly recording public officials at hearings or public meetings or just law enforcement in closed door, the smoky room kind of situation. It was intended to try to protect law enforcement and public officials from people recording them engaged in illegal activity. Luckily, the Constitution won out. The court said, no. We want the public citizenry to record public officials and law enforcement. It's a check. It's, in their whole checks and balances system, if public officials and law enforcement know that they can be recorded and that it's lawful to do so, they'll behave themselves, okay, theoretically. And we have seen that, as more and more cases get, the Ritterhouse case is a prime example of that. Both the prosecution and the defense have said to the jury that it's amazing how much footage they actually have. 20 years ago, it would all be interviewing witnesses and potentially hearsay evidence, and they have to piece it together based on the testimony of people. And now they're just playing videos of what happened. So we are living in an age where videotaping and their devices have made it possible for the public to have a check and balance against public officials and law enforcement engaging in illegal activity, and courts have upheld that we have the right to do that under the First Amendment, and we have the right to preserve that media. It can't be confiscated, can't be destroyed under the Fourth Amendment. So this case just sort of very recent case that upholds all the things that I've just been talking about. Okay, so that's it. So any questions on law enforcement? Yep. Yeah, so that's actually a really great question because it's not entirely clear. In the United States we have this concept called the tutelage, okay? That's the legal term. If I build a fence, and let's say my fence is 8 foot high, so it's taller than the average person, I cannot fly a drone or put my camera on a stick and stick it over your fence. Okay? Even though it's not in your house, you still have a barrier. It's within the tutelage of your property. You have a reasonable, or the property owner has a reasonable expectation of privacy within that tutelage of their home, okay? And I can't take steps that would sort of bypass that. I can't fly a drone over the house. I can't put my camera on a stick and stick it over the fence. I can't put the camera between the blinds and sort of peeping Tom videotape. However, if I have a big bay window and I don't have the curtains drawn and I'm engaged, I shoot somebody and you videotape it, did I have a reasonable expectation of privacy in front of my big bay window? Probably not. And I think there are court cases that are still deciding that one way or the other. But generally speaking, if you yourself are on public property and can easily, just through normal means, videotape something, chances are it's okay to do. There are probably exceptions to that. But, big bay window, more likely. Front yard, yes, front yard, clearly. I don't have a reasonable expectation of privacy in my front yard unless I have an 8 foot tall fence. Yep.
You're in a one-party consent state and you're talking to somebody in a two-party consent state. Whose law applies?
So I think the answer is that the party that you are recording, wherever they are located in, that's the law that applies. So there may be some debate on that, but that's my understanding of it. That's a great question, though. Yep. Well, it's never going to be yes or no. Okay, so as a lawyer, every answer is going to be it depends. Okay, generally speaking, if you are, some like California, for example, has very strict paparazzi laws. Okay, that would prevent you from perching yourself up with a telephoto lens and shooting into the backyard of someone's house. So it's complicated. Generally speaking, though, in Wisconsin, if someone's in their front yard or very plainly in view from a public location, they don't have an expectation of privacy. Yeah, it's still going to depend. There's a lot of factors that go into it. What was the person engaged in? What were they doing? Were they in the process of closing their blinds and you just happened to get a shot right before they closed the blinds? It's not a black and white answer. Oh, yeah, well, that's not a crime because no rights have been violated. I mean, so I guess if someone's growing a big pot plant in their front window in a state where pot is still illegal, and you turn that photo over to law enforcement and say, their living room is a grow site, that is probably not a violation of the law because they didn't pull their blinds. So if you are growing pot in your living room, if a big window, pull your blinds. So yeah, there's a lot of factors that go into it. The reason why it's complicated is it depends on the circumstances. If it's in broad daylight and I don't have the blinds drawn, I have less of a reasonable expectation of privacy. If I'm in the process of closing the blinds, or I'm walking, into the bathroom or into the back of the house, and you just happen to have a super powerful camera that can capture low light or whatever, you still may be violating their privacy if they had a reasonable expectation of privacy at the time. That's a tough question to answer given the circumstances. Yeah, so copyright questions. Generally speaking, just the fundamentals are whenever you take a photo on your camera, you literally press the button, you now own a copyright to that photo, okay, automatically. But you can't enforce that copyright against an infringer unless you register it with the U.S. Copyright Office. That's copyright.gov. And it's very cheap. It's $65, $60 to register the copyright. If you can do, I think it's up to 6 or 8 photos in a single application. If you register the copyright and obtain a certificate of registration, and it's infringed, someone copies it without your permission, after it's registered, you now have a cause of action and can collect attorney fees and statutory damages up to $150,000. Between $30,000 and $150,000 in damages if you have it registered. If you don't have it registered, you can still go out and get it registered, but if the infringement occurs before it's officially registered, you have to prove your damages. And if I'm an amateur photographer, I've never made a dime in a photo, I'm not going to have a great case because it's going to cost $50,000 or $100,000 in legal fees, and I'll get $1 back, in damages, and I won't get attorney fees. So registering your copyright is very easy to do, something all of us can do by going onto the copyright.gov website and reading the forms and going through the process. It's slightly more complicated than ordering something off of Amazon, but not that much more complicated. It's probably cheaper than most of the things that we do buy on Amazon. So if you are a photographer and you're going to release your photos to the public on your website, on Facebook, on Instagram, it doesn't hurt if it's a really good photo that you really like, get it registered. That's going to be the one tool of enforcement that you have that makes it easier, for me as an attorney to get a recovery for infringement. I've had cases where clients have registered their photos. I've gotten them $50,000, $80,000, $100,000 in damages for an unauthorized use of their registered photos. So it's pretty substantial. Yep. So I'm sorry. What is it?
Like a stock image. So like Adobe, you upload your images and they sell them on your behalf.
Oh yeah. Well, that depends on the contract with you and Adobe, or stock, or Getty Images, or whatever it might be. If you are a content provider, you're going to have a contract with Getty Images or Adobe or whatever, and that's going to determine what your rights are. They may enforce them for you. They may not. You know, it's now a contractual question. But you still have a copyright unless you give it up to Adobe, and that depends on what their terms and conditions say. Any other copyright questions? If they put a notice on their own photo, well, actually, I mean, so you are not required to put a copyright notice on your photos. The law doesn't say that's mandatory, but it doesn't hurt. If you do, there's a prescribed way to do it. It's the word copyright, or the C with a circle around it, your name, and then the year in which the photo was taken. And it's not like 2012-2021. It's the year in which it was taken. So I would encourage you to put a copyright notice on your photos. There's no harm in doing so, but not doing so doesn't destroy your copyright. You still have to register it to enforce it. So even if you put the notice on, if someone infringes it, you still got to get a registration to go to the court. Think of the registration as your key to the courthouse. Okay? All right.
We are going to have a 5-minute break if anyone wants to get a drink or something to eat or use the restroom. And then the headliner is up, Mr. Tom Lemke.
Testing. All right, folks, there's just a few moments left before you can get your last glass of wine or a nice fresh drink from the cafe. They're waiting for you if you have any requests.